Hi, everyone. I'm Jay Lazega of Lazega Johanson. Welcome to this session of L&J's Morning Break, joined today by Rob Stein and Justin Respris. Hi, guys. Welcome. Thank you for everybody, to all of you that send texts and emails saying hi and checking in. We love hearing from you. Hope everybody is still surviving and managing in this crazy pandemic time. We think about you guys a lot. So stay safe. All right, we got a great one today. We're going to talk about non-COVID issues. We've got two topics that are pretty impactful for us in the association world. One is a new law affecting condominiums on insurance. That is the classic story of the Georgia legislature overreacting to a non-issue and making new law that is frankly not helpful to us in any way. And the other is relatively new provisions related to service dogs and support animals that may be helpful for us. So this may be good for us. We know that that continues to be an issue for communities. So we'll talk about that. A few quick things first. You guys have been on these before. I think you know how it works. We love your questions. We may not get to answer all of them today, but you can ask questions on the questions tab on your menu bar. Send those in. If we don't answer them today, we'll get back to you individually with questions. We love hearing your questions, comments. Use that. Also, we had great success in our last session in topic suggestions from you guys. We love hearing ideas of what you would like to hear us cover in these morning breaks. So we're going to repeat our prize giveaway. So for this session, the 5 best topic suggestions that you send will win this absolutely spectacular, very soft and comfortable L&J long sleeve shirt. So in the question area, we'd love to hear what you would like to hear from us on topics in these sessions or in articles or in quick facts. Also, we love hearing that you love this, that you guys like using this, but want to remind you that we have a huge number of resources on our website at ljlaw.com in the resources section on not just COVID issues, but general practice, general operating issues, budgets, POA, amendments, meetings in particular. We've literally helped 100 communities conduct their meetings virtually or start their annual meetings virtually this year. Great information on that. If you have questions, you want us to help you, reach out. Send us notes, send us questions, send us emails. Happy to help you on that. This is obviously a time of year and a year where we're doing things differently. And it's new for many communities, conducting your elections by either mail-in ballot or online electronic site, conducting your annual meetings virtually. So we're happy to help you. All right, thank you again for joining us. Rob is going to start on the new insurance law. Thanks, Rob. Thank you, guys.
Thank you, Jay, and good morning, everybody. Good to be together. Good to talk with everybody, and I hope everybody's doing well. We're going to start with the new legislation that is going into effect January 1st, and about water damage from the Georgia legislature impacting Georgia condominiums, just condominiums. So if you manage condominiums, and I asked you to list the top 5 issues that you hate, from what I hear, water losses and water damage would probably be near the top, if not number 1. So, water heaters leaking, washing machines bursting, toilets overflowing, plastic pipes breaking, sprinkler pipes freezing and bursting. If it contains water, whatever it is, at some point it's going to break and it's going to spread its benefits throughout. If it's a high rise, 10 floors below, and if it's townhomes across a dozen units on either side of the unit that's been impacted. So it's going to be a disaster too often. Well, this morning I'm here to tell you how the Georgia legislature has stepped into the fray a little problematic. But the new law does 2 things. First, they did add some clarity to what Jay, Jamie, I, and others have been saying for decades, and that is that the Georgia Condominium Act doesn't require condominium associations to buy water damage insurance. It added some clarity to that. The same conclusion was reached this past summer by the Georgia Court of Appeals. Condos are only required to cover fire and extended coverage property insurance, which covers certain named perils: fire, windstorm, hail, aircraft, riot, vehicles, explosion, and smoke. It doesn't require water damage insurance. Let's move on to what the legislature did secondly. The second thing it did was it made an addition that's going to impact claims, and this is significant. It has really opened the door to owners to be able to make direct claims on a much easier basis than they ever had before. It's going to raise the quantity of claims, and it's going to, again, it's going to allow owners to make those claims. Condominium associations, we all know, have always sought to limit the number of claims. Why is obvious: premiums and the hit that those premiums have to the annual budget. So, you know, condominium associations have managed claims, and for many of them have done it in appropriate and good ways. It has been, if an owner had a washing machine hose that burst and it caused $10,000 in damage, and there was a $15,000 deductible, well, that's a zero pay situation. Why make a claim? To the same extent, if you had a $15,000 deductible again, but you had $16,000 in damage, that's a situation where an owner is only going to get $1,000 from payment from the carrier. And the association might choose not to have a claim filed and write a check to the owner for that $1,000 that they're going to actually get from the carrier, rather than having another claim, another hit on their claims history. So how did associations stop claims? Well, those were some of the ways. Also, they did it the old-fashioned way. A lot of times they just wouldn't generally make it always available, specific information as to who the carrier was, what the policy is, and how to reach the carrier. We wanted folks to come through the doorway of the association so we could help manage the process. Well, you know, owners, as I said, can they make claims? They always have been able to make claims. And the reason for that is owners pay the premiums for the condominium insurance. Most condominium declarations state that the association is a trustee for the insurance, which means owners are beneficiaries of that insurance. And so carriers, we understand, generally would accept claims that come in directly from owners, even though the association tried to be a good gatekeeper to that. So what has the legislature done? It's passed a law that says if an owner has a potential claim or a submitted claim, then they can make a request to the association, and the association has to provide them with a certificate of insurance within 5 days of that request. And if they've have a fully submitted claim, then the association has to provide the name and contact information for the adjuster that's been assigned to the claim. So, you know, it's going to put owners in a much stronger position to impact what premiums are going to occur to associations, but that's where we are. The legislature has stepped in, you know, for whatever reason. Lastly, you know, does any of this impact the need to buy water damage insurance by a condominium association? No. You know, for most, if not all condominiums, you should be buying water damage insurance, probably at a high deductible, but it's the fail-safe, it's the safety net for that disaster that could occur, and owners who don't have an HO6 or HS6 with proper coverages and deductible coverages, you want to have that so you don't have a disaster occur. So with that, let me throw things over to Justin. Justin, go ahead, please pick up. Thanks.
Thanks, Rob. Just switching gears a little bit, wanted to talk with you all this morning regarding service animals and support animals and some of our obligations under the FHA and ADA. Generally, when we talk about service animals and support animals, they get lumped into one group. However, there are some significant differences between the two. First, the ADA defines a service animal as any dog that has received individual training to do specific work or perform tasks for the benefit of an individual with a disability. If the animal in question is not a dog, then the animal does not qualify as a service animal, but it may still qualify as a support animal under the FHA. So when we talk about these issues, we get questions from boards and managers. Hey, we've gotten this request for an exemption to our pet policy because this owner is claiming they have a service dog. What can we do? What can we ask? Well, the first step is to actually observe as opposed to ask. Is the need for the dog readily apparent? Is it readily apparent that the dog has been trained to do a particular task for the benefit of an individual with a disability? Is the dog guiding an individual who is blind? Is the dog assisting with or pulling a wheelchair for an individual utilizing a wheelchair? Is the dog assisting someone with an observable mobility disability? If so, those situations, the issue or the need for the dog is readily apparent, and there is no further need for an inquiry as to that disability, and we probably need to make an exemption to our pet policy. If the need for the dog is not as readily available or readily observable, rather, there are two questions that we can ask. Is the need for the dog required because of a disability? And what has the dog been trained to do? And if the individual is able to answer yes to the first question and is able to describe the types of tasks or work that the dog has been trained to do, again, that pretty much ends our analysis there, and we need to make an exemption to our pet policy. Now, even if the dog or animal does not qualify as a service animal, it may qualify as a support animal under the FHA, so we need to continue the evaluation. An emotional support animal or a support animal can be one of two flavors, really. It can be an animal that has been trained to do a specific task or perform a particular type of work for an individual with a disability, or it can be an animal that provides some type of emotional support or comfort or well-being or companionship for an individual with a disability. Again, boards and managers will ask, well, what can we do? What can we ask? The first part of the analysis is the same as for a service animal. Is the disability readily apparent? If so, we can ask about the nexus or the connection between the disability and the types of work that the animal or dog does. But as far as asking or inquiring into the disability, it pretty much stops at that point. If the disability is not readily available, there are some questions that we can ask. Has the requester provided any type of proof of disability? Proof of disability being some type of determination from a governmental agency regarding the disability, some type of receipt of disability benefits, or even the traditional doctor's note or information from a medical professional with some personal knowledge as to the individual and to the disability. This is the area where we've had some consternation over the years regarding homeowners submitting or residents submitting some type of documentation they've received from some online service, a www.emotionalsupportanimal4u.com type of situation. The owner has gone in, put in their information, and received some type of certificate from this online vendor that states they have some disability that requires a reasonable accommodation for their animal. Well, HUD earlier this year actually issued some guidance on this very topic and stated in no uncertain terms that on its own, these types of certificates are no longer or are not sufficient to substantiate or to support a need for a reasonable accommodation as to that particular animal. Now, whether the disability is readily apparent or not, insofar as the analysis regarding FHA and support animals, we can still ask if there is some connection or nexus between the disability and the dog or the animal and the tasks or work that they've been trained to do. And I'll give an example of this a little bit later on. If an owner is able or a resident is able to show all of these things, then we probably need to make a reasonable accommodation to our pet policy for this animal. In addition, whether we're talking about service animals or support animals, there are additional considerations that we can take into account. The animal does need to be under the control of the owner or the handler. The animal needs to be housebroken or house trained, and the animal cannot be a direct threat to the community. Now, when we talk about being a direct threat to the community, there needs to be an analysis as to that particular animal and the actions of that animal. The determination cannot be based on the size of the animal or the breed of the dog. Has the animal been threatening to our community members? Has the animal bitten one of our community members? Again, the analysis needs to be directly related to that particular animal. Also, the animal and the owner need to still abide by the general rules and regulations of the community regarding leash regulations, or the animal needs to be in control of the owner. The owner still needs to pick up any waste that the animal leaves in the community, and also the owner and animal need to abide by nuisance and noise regulations of the community. Lastly, HUD has stated that regarding emotional support animals or support animals, generally they're going to be common household animals, your dogs, your cats, your rabbits, a fish. Generally, if it's more of an exotic animal, it will not qualify as an emotional support or support animal. However, HUD did provide one specific example of a exotic animal qualifying as a support animal. The example that HUD provides was regarding a capuchin monkey that had been trained to do a particular set of tasks. The monkey had been trained to go to the refrigerator, open the door, retrieve a bottle of water, untwist the cap, place a straw into the bottle, and place the bottle into a holder that will allow an individual that suffers from some type of paralysis disability to utilize that bottle and drink from that bottle. In that scenario, you have an animal that is not a dog, that has been trained to do a particular set of tasks for the benefit of an individual that suffers from a paralysis disability. There's an obvious connection or nexus between the tasks that the animal has been trained to do and the need for that animal and the work that the animal does. In that situation, HUD finds or would find that that animal is an emotional support animal or a support animal. Guys, that's been very high level general information. If you have any additional questions, please feel free to utilize the question function here or email us directly. This can be a multi-step analysis and it can be contentious issues regarding pets or service animals. People love their dogs. So please let us know if you have any additional questions, and we're more than happy to help you walk through the issue.
Awesome. Thank you guys. That was great. I'm pretty sure I need that monkey in my life. So a couple of quick comments. HUD, Justin covered, HUD actually gave us a little help on this recently, and scaling back on their wide open, anything goes Wild West. Someone brings you a $20 internet emotional support animal certificate and nothing you can do. They realized that there's a huge amount of fraud in this issue, and they pulled back and formally said, look, we're going to allow you to ask some reasonable questions when it's not obvious. Why do you need this dog at the pool? Why do you need an exception for things? And that connection has to be established by that kind of information, like therapy, medical professional statement. Not only this person needs an emotional support dog or no longer emus, but whatever it may be, but why? We understand they need it, but why do they need it at the pool? Why do they need it walking through the lobby? The specific accommodation the person's requesting, we now can ask for a connection demonstration. And then on the insurance, it seems maybe innocuous. The legislature just saying, okay, owners can ask for certificates of insurance. But what they've really done, essentially, is say without saying, look, we're not going to let you, the board, make the decisions anymore. We're going to let homeowners go directly to the carrier, make a claim on something that we may have said, look, that's BS. We know you had that water damage 4 years ago from something else, or this is not $18,000 of damage to clean one area of your unit. So they've essentially removed us from the gatekeeper. Now, practical advice that we're all giving is still try to do that. Someone requests that information, we have to give it, but I think it's still fine for us to say, if you want to file a claim, provide us the information and we'll make a determination and file. We'll see how that goes. So next couple of years will be interesting to see how these two things play out. But all right, thank you guys for coming. We miss you guys a lot. Hopefully we'll be able to see people live again. Reminder, LJ Law resources, ljlaw.com resources for a lot of information. We've gotten a couple of topic suggestions. We'll keep this open a little longer for you to send that and your last questions. Again, we miss you guys. Thank you for joining us. Thank you for all the positive comments about these and the e-blast and articles. They mean a lot to us. Stay in touch, stay well, stay safe. Thank you, everybody.